Okay, my clock on the computer says 10 o'clock, so we'll get started. Good morning. My name is Judge Brian Lambert, presiding here today. Welcome to our new wave session of oral arguments here in the 5th District Court of Appeal. The case that we have now at 10 o'clock is Rose HARR versus State of Florida, case number 5D183946. Each side will have 20 minutes for oral argument. Appellant, I will reserve 5 minutes for rebuttal time. If you want some different amount of time, let me know. You'll see the clock counting down. I'll try to give you a heads up once you get into rebuttal time. Obviously, you can keep going if you'd like. That's fine. If we have any technical difficulties or you can't hear us or we can't hear you, we'll let you know. We'll stop the clock and try to figure out what's going on. That being said, I see the attorneys are here and the judges are here. So, Mr. Sullivan, if you're ready to proceed, go ahead, sir.
I am. Good morning, Your Honors, and may it please the court. My name is Ronald Sullivan, and I represent the appellant, Rose HARR. This is a case arising out of a criminal conviction in which Ms. HARR was convicted on 2 counts relating to a conspiracy to commit bribery and conspiracy to commit bid tampering. We have put forth 7 independent grounds for the court to consider, which we maintain requires reversal. The 7 are independent. They are not reliant on each other. Any one in our argument is sufficient for reversal. The first argument, Your Honor, is one that has been where there is significant doctrinal support. It is that the court below read a standard principle instruction for a conspiracy count, a standard principle instruction for a conspiracy count. Now, it's clear in this jurisdiction that that's improper, that's error. And this goes—
Sullivan, let me interrupt you for a second. The instructions that were read in order of the information which charged various crimes, correct?
Yes.
And the instructions on each of those individual offenses were correctly read, and the elements were correctly set forth to the jury, correct?
It's hard to answer that yes or no because of the mismatch between the label, the heading, and the substance.
The substance, that the jury was given, the elements of the offenses were correctly presented to the jury, were they not?
Correct instructions were given to the jury. The question is for which count, though. So I'm not trying to evade your Honor's question. So yes, the substantive areas were read to the jury. It is unclear to my thinking whether the jury was able to connect up the heading with the substance.
Well, it seems that it was the order of the instructions that you're quarreling with, the juxtaposition between the 2 counts that she was convicted of. That really seems to be your problem more than the substance of the instruction themselves.
Well, there is a substantive issue as well, but yes, Your Honor, correct.
Well, I don't understand then the issue. I mean, did you ask for a different order of the reading of the jury instructions?
Well, there was a general objection below, as the record showed. There was not a specific request for a different order. But the fact that there was this mistake, this error with respect to how these instructions were read to the jury prejudiced Ms. HARR because of the different mens rea requirements for conspiracy versus the substantive underlying account. And that's pretty much our substantive argument, Your Honor, that the breadth of potential liability under a aiding and abetting standard is significantly broader than it would be had the proper instruction been read. And it's in all likelihood that Ms. HARR was convicted under an incorrect standard.
It appears to me that the instructions were properly read as to each count. It's just, you know, your problem with it, the heartburn you've got, is the order. The fact that you know, one instruction came before the second instruction as it was set out in the information.
And it's significant heartburn, Your Honor, because that's what the jury heard, and the jury will have connected an improper jury instruction with a charge, and that can't happen. That can't happen. There is a likelihood that Ms. HARR was convicted under the wrong standard.
But didn't your first issue is the jury instruction on count 5 is improperly worded? The bid tampering principle to commit bid tampering, didn't it track the language of the statute 838.22 1A and sub 3? I mean,
well, Your Honor, as Judge Cohen stated, the way in which it was read to the jury paired the principle or the standard charge that of a principle with the conspiracy charge, and that's where the confusion rests. And it is a significant confusion, and it's a confusion that reaches constitutional proportions because it touches and concerns due process. So our argument is not simply a formal argument, that is the order in which it was read. It touches and concerns substance because the order in which it was read permits a jury to convict on the wrong charge. So I'll just say a couple more words about the first one. And it goes back to first principles, Your Honor. The reason that conspiracy charges has such a stringent mens rea is because otherwise the net would be too great, too broad, too capacious. So the mens rea required for conspiracy is a self-effectuating limiter that limits the scope of liability. And what we have here is a potential conviction based on a charge where or an instruction where only assistance, a different sort of mens rea was present, and that's our argument here. And we think that there's significant. There was a significant opportunity for the jury to have misread that. One brief point here, just to address an argument raised in the state's brief on this point. The state maintains that this argument is not available to Ms. HARR because it wasn't properly preserved below, and we somehow created the issue that we now complain of. I'll just state that the government here misreads the court in law, where law said that because of a different procedural posture of the case, it declined to overturn a conviction. Here's the key distinction here. For this sort of equitable, unclean hands argument that would prevent Ms. HARR from stating the claim, there has to be an affirmative act below by the lawyer that causes the thing that we now complain of. It can't be just the absence or simply the absence of preserving the record. That would completely eviscerate an entire additional body of law. So in that case, the lawyer below specifically requested that language be removed from the instructions. And when that language was removed, that caused the very problem that they complained of. And that was the nature of the case in law. So we think that Evans is still the proper case here, and that this is
counsel, just turning back to the facts we have, how do you get the fundamental error here that we should find the sequencing, the unobjected to sequencing of the jury instruction was so terrible that it denied your client a fair trial? I mean, there was evidence from which a jury could conclude that she had engaged in a conspiracy, couldn't it?
It touches and concerns the due process question that Your Honor raises, and that the error was fundamental in the sense that, to the degree that it's more than pure sequencing, to the degree that a jury potentially convicted on the wrong charge, that goes to the very nature, to the very heart of a criminal trial. Due process requires notice and requires that people be convicted of the thing for which they are charged. To the degree there's even an ambiguity there, that ambiguity should be resolved in favor of Ms. HARR. So we do believe that it has reached the due process level of a fundamental error. That said,
I'm trying to understand what in the record makes us believe that the jury misinterpreted the jury instructions.
Well, again, we can't. I'm sorry, the sound broke up, Judge Cohen.
Is it the fact of the conviction that makes you believe that?
Well, not just the fact of the conviction itself, Your Honor, although that certainly aids to the conclusion, but it is the fact of the mislabeled, missequenced charge that allows for that inference. And we think that's more than sufficient. Again, at the very heart of due process requires notice and that people are convicted of the things for which they are charged. Now, the law doesn't permit us to go back and question the jury and ex post and figure out what in the world they were talking about in the jury room. But we do, Your Honor, have this evidence in front of us as to what was read to the jury. And again, to the degree it's even ambiguous, that's sufficient, because that ambiguity should be resolved in favor of Ms. HARR.
One of the other things you argue is you don't like the jury instruction about competitive bidding process. It says the court erred in defining that. Are you saying that the instruction itself was erroneous, or that it was unnecessary, or what is the specifics of your argument?
That pardon me, Your Honor, that the instruction was both unnecessary and prejudicial. So it's 2 points. The plain language of the charge itself was sufficient. The gravamen of our argument is that the court below injected a character trait into the definition that the legislature didn't put there. So for a strict reading of the legislative intent, it didn't require companies that are, quote, responsible companies only be allowed to apply. It allows anyone to apply, and if they meet certain requisites, then they can win the bid. It's the injection of this normative phrase of responsible that we object to. And we can see from the prosecutor's argument at the end that the prosecutor relied indeed on this notion of a responsible actor. And it's that injection that caused error, because given the rest of the trial, which was about bid tampering and bribery, a reasonable juror could conclude that, well, these guys aren't great actors, so they're not responsible, and they somehow don't meet the statutory definition. That cannot be the case, because the legislature did not write that. So that's the nature of our argument there.
Didn't the trial court craft that instruction based on case law that the court was reading at the time? And I mean, they didn't just pull out of air. They were looking at case law and use that instruction, and it was basically generated as a result of the instruction given at your defense counsel's request about Mr. Needleman being a constitutional officer who is not required to participate in competitive bidding. So, I mean, it seemed to flow as a result of the instruction that defense was able to obtain. So, I mean,
well, we have no quarrel with the constitutional officer aspect of the instruction, but I am unaware of no. That's right. So I certainly wouldn't be here objecting to it. But we did not certainly ask for the injection of the normative phrase responsible person. And we are unaware of any case in Florida that provides that instruction. And we do think it's problematic and prejudicial.
You also, one of your last issues, or maybe the last issue, is you think that the court erred in not responding more affirmatively to the jury question about whether a lobbyist could receive commissions. Doesn't a trial court under 3.410A have the discretion whether to give an instruction at all?
Absolutely, and we think that discretion was not exercised properly. It is a classic question of law. There was an apparent confusion there, and the court should have cleared that up. So I hear the court does have broad discretion, but the court can abuse its discretion when there is evidence that a jury is clearly confused about something and that a jury might base its conviction on a misapprehension of law, which we think is the case here.
Mr. Sullivan, you're within your rebuttal time.
Absolutely, I will reserve.
Okay, good enough. Thank you, counsel.
Thank you.
All right, Ms. Kohler.
May it please the court, my name is Pam Kohler, I represent the state of Florida in this appeal. I'll go follow his argument. As far as the first issue, number one, this precise argument that was argued in the brief was never raised below. They didn't object to the sequencing. They mostly were complaining about that they wanted the corrupt intent in the principal instruction. And they complained about the captions, but there was no complaint about the sequencing in this case. And I would submit that, number one, there was no jury question indicating that the jury was confused about the instructions. Number two, they were given a copy of the instructions with that order established as far as setting out what the three different counts were. And the fact that they were able to find the defendant not guilty of a principle to commit bribery, but guilty of conspiracy to commit bribery, I would suggest indicates that they were well aware of what their burden was and what it was that they were looking at and how to interpret those instructions and the crimes charged. And finally, as this court noted, the statute, they sent out the correct law in all these instructions, and the statute itself in 838 talks about, they said both of those subsections that the state was proving. As far as the competitive bidding process, it was a correct statement of law. What happened was the state wanted that instruction, and the judge kept removing portions of the instruction that were found in that case law that the defense didn't like. And then finally she agreed not to give it at all. But then once they asked for the instruction on a constitutional officer, she said, okay, I'll put it back in. The state or somebody asked the defense if they were okay with it once they removed the financially capable, that sort of language that they found so defensive, and they said no. And their only response was because it wasn't given during the Needleman trial. So that was what they're most upset about at the trial level. And number one is a correct statement of the law. And she was arguing she was a responsible bidder, that she had all this, vision. She was a visionary trying to open up her business down here in Florida. So it's not as if, and the fact that she had done the medical scanning. So it's not like she wasn't arguing that she was a responsible bidder in this case. So there shouldn't have been no problem with that. And finally, the jury question. I didn't really stress it enough in my brief, but there really was no evidence that the money that went to Dupree, the extra money, was any sort of commission. If you notice in the opening statement, defense counsel argued it was a sales commission. And what happened was during the trial, that argument was shot down when the lead accountant said, we didn't give sales commissions in 2012. So then he has to backstep a little bit and suggest, well, then it was a lobbyist commission. And there was no evidence ever presented of a commission given to Matt Dupree as a lobbyist or as a sales commission. There was never any evidence. So number one, there was no evidence to support this jury instruction. Number two, she was never charged with unlawfully paying a commission. So that it wasn't relevant as far as that. And also number three, this theory of defense, assuming it's some sort of theory of defense, wouldn't have acquitted her had the instruction been given. Okay, so you call it or you name it a commission rather than a kickback. I mean, what happened was they sent more money than the contract really required to do what they were going to do, $30,000 or whatever it was. That went into Matt Dupree's account, and then he would kick back some of that money to Needleman's campaign books, which was never reported by Needleman's campaign. So I don't care what you call it, whether or not it was a commission or a sales commission or whatever, it was a kickback. And it basically it's a circuitous way of getting the money from Blue Ware and Needleman back to Needleman's campaign so that he could, which the state was able to show, he used that money, for example, to send out flyers for his campaign.
Ms. Kohler, do you know what the status of the Needleman case is currently?
I don't know currently. I know that we tried to appeal that and we were denied that appeal. So I assume he's going to be retried. And of course, with the coronavirus mess, I don't know.
Okay.
I should have looked that up. If this court has no further questions, the state would rely on its brief and ask that you can affirm the convictions and sentences. Thank you.
All right, counsel, thank you. All right, Mr. Sullivan, you have, looks like 423 on rebuttal.
Thank you, Judge Lambert. I'll pick up where the state left off with respect to this question of the jury question, whether it's, the state argues that whether it's a sale commission or a kickback, it's a kickback. I'll just point out to the panel that that's classically circular. There are formal, substantive, and structural differences between commissions and between kickbacks. And if a jury thinks that a commission is per se illegal, or as the state now argues here on appeal, that they are one and the same, that would manifestly be an incorrect statement.
Weren't there two witnesses who testified? Right. Weren't there two witnesses who testified that Blue Ware did not pay commissions back then?
There were at least one, and there may have been two. Not disputing, Your Honor. There was at least one. But if a jury found that in that particular instance, not their general practice, in that particular instance, it was a commission as opposed to a kickback, then that would be fine. Nobody testified.
Who testified that it was a commission?
There was not in the record affirmative testimony that there was a commission.
So we have 2-0. I don't understand the confusion.
Well, it's not as though it's a scorecard. If the jury inferred from the evidence that a commission was paid, that would be a fair inference. They were in unique.
What evidence did this jury have to support even the inference that it was a commission?
That they were in a unique space, that they had to that they were attempting to secure contracts in a space and in a way that the company had not done it before, and this may be one instantiation of that of that general claim.
So none. This is the answer to that question.
I wouldn't say that, Your Honor. I would say that there is something upon which a reasonable juror could base an answer, and the jury, and that's manifested by the question itself. The question didn't come from whole cloth. So I'd like, if I may, in my remaining time just to make one factual argument and one conceptual argument. And this is the second point in our brief, this notion that Ms. HARR conspired with someone to solicit a bribe from her. It's this very odd argument that HARR conspired with Needleman to solicit and accept a bribe for itself. Picking up Judge Cohen on your last question about where is there evidence in the record, there's no evidence in the record that Ms. HARR conspired to have someone solicit a bribe from her. There may be evidence that she solicited conspire with someone to accept a bribe, but not conspire with someone to solicit a bribe. The only evidence in the record was that someone came to her and said, "Hey, if you want to do business in here, this is how you do it." That was the solicitation. Nothing in the record. And the last issue is a conceptual issue. That's our 3. This is the material information the material information argument. So on the government's theory, if someone possesses any information whatsoever prior to the bid process, then they are somehow subject to the criminal penalties under this section. And that is far too broad a read of the statute. I see my time has expired, Your Honor. Thank you for.
You want to finish what you're just saying? You want to just go ahead and finish? That's fine.
Oh, thank you very much, Your Honor. So the point here is that imagine arguendo that there was someone who 2 years ago, a company that did work on a school and had intimate knowledge of the pipe system and the HVAC system and so forth. 2 years hence, there's a bid there, and they bring that knowledge to bear based on their prior work. On the government's theory, that company would be liable potentially for a criminal charge. And conceptually, there's not much space between that and the evidence of what happened here, where Ms. HARR's company was engaged ex ante in work in the space that was subject to the crime. And that work ex ante can't then serve as a basis for liability once a bid is put out. The clock has to start, I respectfully submit, once the bid is put out.
All right. I just wanted to say before, Judge Lambert wraps up the session that I thought this case was very well briefed by both parties, and I just wanted to compliment both of you on the briefing.
Thank you, Your Honor.
Thank you, Your Honor.
All right, counsel, we certainly appreciate your argument and your patience with our technology here. So we'll sign off and adjourn for the day. Have a good day.
Thank you, you too.
Thank you.